comment?
Today we're about to open the meeting of the Gilliam County Court Special Session. It's Wednesday, September 26th. It is 10 a.m. We're downstairs in the conference room in the Gilliam County Courthouse. We have a public hearing on the following matter. It's ordinance number 2018-03 in the matter of an ordinance providing amendments to the Gilliam County Comprehensive Plan to add an aggregate resource site, County ID number 654, which is the Philippi Canyon, as a Goal 5 protected site to the county Goal 5 inventory list of aggregate resource sites in compliance with the State of Oregon Planning Goal 5 requirements, and rezoning the subject site to significant resources, combining zone and approving the site development plan for the upcoming 2018-19 I-84 maintenance project. This is the time that's duly set and advertised for a public hearing to receive public input and respond to questions on ordinance number 2018-03 in the matter of an ordinance providing amendments to the Gilliam County Comprehensive Plan to add an aggregate resource site, County ID number 654. Philippi Canyon as a Goal 5 protected site to the County Goal 5 inventory list of aggregate resource sites in compliance with the State of Oregon Planning Goal 5 requirements, and rezoning the subject site to significant resources, combining zone and approving site development plan for the upcoming 2018-19 I-84 maintenance project. So it was a little bit redundant there, but this is kind of the requirement. This is a legislative hearing. At this time, the hearing is now open. The rules for this public hearing will be, the hearing is being recorded. All those in attendance are asked to sign the attendance sheet and please include your mailing address. A 5-minute time period has been allocated for each person. If you need more than 5 minutes, you must request that prior to testifying. Again, the proceedings are being recorded, so no clapping, cheering, jeering will be allowed. We ask that you be courteous and orderly in the hearing. All persons testifying must be recognized by the chairman. State your name and address, and if you are representing someone else, please state who you are representing. To expedite the hearing, the county court members may ask questions of persons as they testify. These are the rules. Do we have any questions? The order that we're going to go through here is we'll receive a staff report, then we'll open it up for public comment, we'll close the hearing, we'll deliberate, and then the county court will possibly have some actions. Is there any questions in regards to the order of testimony? Well, if not, then we shall move on. So at this time, will the staff please present the staff report?
Thank you, Judge. My name is Dan Meter. I'm a longtime Oregon land use planning consultant, and I'm with Tennyson Engineering. I've been with them for 46 years. Nick Kramer has left Tennyson Engineering, and I'm sitting in for him, and I've had about a day and a half to prepare. The only staff report I can give you is oral, and I'll give you what I know about the hearing and the process. My understanding is this was to be a review of the findings document and adopting the findings document, which is an administrative action, and no public input would be required. I would almost think you would need to do the findings document before you do the ordinance. Okay. Now, the ordinance, I understand, is open for public hearing, and you do have to go through that process. But I would think the findings document would be first in that, and you might want to hold the hearing in advance and do that so that you have an ordinance. You're relying on an adopted document,
Okay.
an approved document in the ordinance.
Okay.
Barring that, the ordinance simply follows state statute for Goal 5 and changing the comp plan and the zoning ordinance to accept this site as an aggregate resource site. There's 54 pages of findings. I don't propose to go through those one by one, but I've read through them, and it's fairly straightforward. I understand it was a contentious decision, but you have made it, and it's time to move on.
Okay. Let me back up here.
Chamber, this is Reuben Cleveland here.
Yes, okay, I wanted to check and see who all we had on the phone. So we have Reuben Cleveland, who is county counsel. Is there anybody else on the phone?
Yes, Stacy Postgate from DOJ.
Okay. So I have Ms. Postgate, Mr. Cleveland, anybody else? Okay, Reuben, were you able to hear Mr. Meter's comments?
I was, and I concur in what Mr. Meter is saying there. I don't have anything to add. I just want to make sure that what we're doing in this hearing is following the first reading procedure for the ordinance so that we can have the second reading at the next meeting that is 13 days after this one, or at least 13 days after this one, so that we're following the statutes on adopting the ordinance.
Okay. So right now, as far as, I guess there was I made comments about opening up a public hearing. What I'm hearing from Mr. Meter is that really we should be reviewing the findings and the facts and coming to a conclusion on those. Is that correct? Okay. And approving those, I take it as what you're saying. And then we're going to move into the ordinance portion of this as
that would be the public input
Okay.
portion of the hearing.
All right. I think that makes perfect sense. Are you two?
And my understanding is that basically, I mean, we came to a tentative approval last time, and now we have the final document
Right.
that we're looking at today to make, and seeing that it matches up with what we said
Okay.
during the last meeting.
Okay.
Does that sound?
That's
Yep,
exactly
that's,
correct.
That's the way I see it. So,
Right.
okay.
Right.
All right. So we were able to go through, you know,
Do you get copies of whatever you're looking at? Because we do not.
a couple copies.
We have not received it by email. Thank you, Sandy.
So
Can I get an extra copy before?
there were 45 findings.
Anybody else want a copy?
Were we, do you want to go through them individually? Virtually everything I read, it really did, carry what we wish to have done.
I did come across one thing that may need to be corrected. I think it was just an error in the printing on page 27 at the last big paragraph down there. And at down on the last line of that, the sentence says, "The court finds that the criteria is met with conditions relating to the closure of Heritage Lane as discussed below and incorporated herein by reference." And I believe that should have been the
Quinton Canyon,
Yes,
Quinton Canyon Road.
right. Don't ask me how I spotted that. Is Sandy getting more copies?
I believe he is, yes. Yeah. Well, perhaps what we can do is recess a short period of time until he gets back.
Yeah.
Yeah.
of recess now.
We're out of recess back into,
I have a question for Dan. So at this point in time, is it just that the court needs to approve the findings by, and do we do that by consensus or do we do that with a motion?
You do it with a motion.
motion, yeah.
And I don't believe we need to go through each and every finding. I think the findings were put in the packet that went out. If there's some specific questions, certainly we should go over those. Commissioner Weimer's catch on the Clinton Canyon Road was certainly a perfect example of that. If there's anything to change or anything where we have questions, now's the time to do it. And we can adopt it as by motion as we have in accordance with what we've decided here, meaning we can have a motion to adopt it with the changes that we flesh out at this meeting.
So Commissioner Weatherall, did you have anything in
No.
here? I did not. I think that's a really good catch on the Clinton Canyon Road, because I went right over the top of it. This is, a fairly, in many of the land use applications, in my time on the planning commission, this is probably the most extensive one that I had in my 13 years on there. So, yeah, easily. And that includes a lot of wind projects.
Mr. Carey and I worked on one in Hood River in the early 80s. It was 114 pages.
Okay.
Well, if not hearing any more discussion about I would move we approve the findings of fact and conclusion of law for Philippi Canyon Quarry, significant resource application and site development approval.
I'll second.
Okay. It's been moved and seconded to approve the findings of fact and conclusions of the law of the Philippi Canyon Quarry significant resource application and site development approval. Any further discussion? No. Okay, there being none, all those in favor?
Aye.
Opposed? Okay. Good. All right. Findings of fact set aside. Okay, so it's at this time, Ruben, that we'll move into public comment. Am I correct? Because we reviewed the facts, reviewed court order number 2018. What? I'm sorry.
Oh, I just was agreeing, that's fine.
Did you take us out of the public hearing? Did we close the hearing?
No, we're still in public hearing.
Okay.
Yep.
Yeah.
Yep. So.
We simply put it in abeyance.
Into recess, okay.
Mhm.
Yeah, okay.
Okay. So at this time, I guess, we do have a list of individuals who wish to testify. I guess the first one we have on is Lori Bartolome.
I'll let Brian go first.
Okay, so we'll lead with Brian Meese.
You want me up here?
Yeah, right up here would be great.
I'll make
Excuse
this.
me, Judge.
Yes.
This is Stacy Postgate at DOJ. I didn't receive a copy of the ordinance, and I've just confirmed with ODOT that they haven't seen it. Is there any way that someone can email it to me?
Yeah, Stacy, this is Sandy. I'll email it to you right now.
Great, thank you, Sandy.
Okay. Okay, this is in regards to ordinance number 2018-02, correct? Yes.
Three.
Three. Okay, it's to 3. Yeah. I know, there was a... Okay, Brian.
Brian Meese, representing the Meese Family Trust. We obviously ordered the subject property. I just want to reiterate our testimony that's on file and request one more time that our sole objective here would be that we take a bigger look at this whole natural resources issue and make this decision regarding these rocks in a larger context that includes all the other implications, whether it be economic, whether it be wildlife, whether it be cultural and historical. And I just think the beginning of this was in a vacuum, and I think we should have had a bigger discussion to start with around the Goal 5 resources and not just center on ODOT's request to tear down these walls. So anyway, I'm going to leave it at that for now. You've heard me before.
Thank you.
Lori Bartlemay, I concur with Brian. I think we should have had more time to discuss destroying the outcroppings. I think that there is not particularly justifiable circumstances to destroy them. This was brought to the court January 24th. They didn't have their first meeting until May 22nd. That is an awfully large gap, and I don't feel that the adjacent landowners or the people affected by this were given proper time to prepare. So I would like to see nothing happen today. I would like to see Gilliam County Court look more at protecting Gilliam County residents instead of ODOT. Thank you.
So just to clarify, Lori, this was brought to the Planning Commission in January.
Okay, January, that's still an awful large gap.
Right, and then it was a Planning Commission again
Right.
in May.
It was still a large gap, and
Right,
I don't
right.
think there was enough time
Yeah,
allowed.
I just wanted to clarify that it
Right.
really wasn't brought to the court, it was brought to the
Correct.
Planning Commission. Okay, so. All right, we also have Connie Anderson.
I guess you kind of perhaps caught us all ill-prepared, as I guess I was under the impression that there was to be no testimony today. It was just a hearing, a reading, and administrative.
Okay.
So I'm ill-prepared for a formal response, but I will say that, refer to my opposition in the past, and I guess it'd be redundant for me to, but still refer to what both Lori and Brian stated about the time gap and the, I guess, seemingly planned exclusion of the landowners involved, as I know several of them were not notified. Myself, I was notified, however, the landowners closer by were not notified until we brought it to their attention, and they sought out why they were not notified. I guess the whole time gap stinks. The lack of consideration for the landowners and what we have had to offer reeks also. We have valid concerns. We have, I think, the historic value that is being ignored, that was identified in the comp plan as being protected, is not being protected. It's being completely disregarded. The comp plan that was designed for that is being completely disregarded. And I guess just nothing more new, other than I'm very disappointed in the court. That would be the end of it.
So I guess I have a question with, I know you're on the Planning Commission, we have Michelle here. So this came in January 24th, this request. When were the landowners notified that this was something that would be coming up?
I would have to look in the file. Judge Chapin, I believe that January 24th date is the the application completed date, deemed completed date, but I would have to go back and look in the file.
Okay, okay. So I was going here first, I'm coming this direction. So, who wants to
Let
speak?
me just, my
Brian.
point is that they're, Brian Meese Family
That's
Trust.
all right.
My point is that there was conversations going on between ODOT and the county long before that ever got to the County Planning Commission. Those conversations go way back into a discussion leading up to that final document. We know that there were documents from Tennyson in that application, and so there obviously was conversations long before it ever got to the Planning Commission as a final document that was complete, so.
Okay. Lori.
We never received any documentation from anyone about anything.
Okay.
And that road closure is going to affect us a great deal.
Okay.
I know, our letter was late April. But I know that there were conversations prior to January, as in last fall. And we were watching and waiting for and asking if this was in the works, and it was denied that anything was coming down the pike until we got our letter in late April.
Okay.
Which is when she shared it with us.
Okay. Okay. Either one of you have any
No.
further questions? Okay. I don't believe we have anybody wishing to offer public testimony. So at this time, I guess it's time to close the public testimonial portion hearing of this and move into deliberation. So with that being said, we shall close the public testimony portion of the hearing. Move into discussion.
If I'm understanding the process on this correctly, we've already approved the findings of fact.
Mhm.
It seems to me that the court order is something that we could do at the next meeting. So we're at the point now where we approve the ordinance, read it by title only.
The first reading.
Yeah. I would move that we have the first reading of ordinance number 2018-02. 03
Yes.
by title only.
Second.
Okay, it's been moved and seconded that we have the first reading of the ordinance 2018-03 by title only. All those in favor?
Aye.
Opposed? Okay, Sandy, I'll let you go ahead and read.
In the County Court of the State of Oregon, in and for the County of Gilliam, ordinance number 2018-03. In the matter of an ordinance providing for amendments to the Gilliam County Comprehensive Plan to add an aggregate resource site, number 654 Philippi Canyon, as a Goal 5 protected site to the County Goal 5 inventory list of aggregate resource sites in compliance with the State of Oregon Planning Goal 5 requirements, and rezoning the subject site to significant resource combining zone, and approving site development plan for upcoming 2018-19 I-84 maintenance project.
I move that we accept the first reading by title only.
Second.
Okay, it's been moved and seconded that we accept the reading of the ordinance by title only. All those in favor?
Aye.
Aye.
Opposed? Okay. Carried. Yes.
Ask Ruben to explain the appeal process so that everybody's in a clear understanding.
Ruben, can you explain the appeal process so that everybody understands what that can be or will be?
The appeal process regarding the ordinance or specifically what would someone...
Would be the ordinance, that's it.
I believe that, well, Dan feels it'll be the ordinance,
And the findings.
and the findings would be,
Which are incorporated.
Okay. Okay, well, I mean, my thought is that would be as far as the findings and such, that would be an appeal to LUBA.
okay.
Actually, I would turn it over to Dan on what the LUBA appeal would entail.
Okay, I didn't want to cross you up, Ruben. Once the ordinance is formally adopted at the second reading,
Okay.
I assume that you only have 2 readings.
Right.
Then that is the final decision by the county court. Then the matter can be appealed as a package to the Land Use Board of Appeals. It's a 21-day filing deadline from the date that the ordinance is actually signed. And I wanted to make that clear to everybody here. So you have 3 weeks after the final decision, which is when it's signed.
Okay.
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 And also, okay, so we have this order. We have an ordinance and we have an order. Somebody needs to explain.
Yeah, that's.
The ordinance actually goes into, the ordinance amends the comprehensive plan and the zoning ordinance and the site plan.
Yeah.
The order merely approves these findings.
Oh, okay.
Okay.
And the order is basically the vehicle of the governing body that's imposing these conditions onto ODOT for the closures, for the whatever ODOT's going to do under this. This is the document where the court says you have to abide by these conditions.
Okay.
Okay. Okay. Okay. So what, we're good, right?
Next court meeting.
Next court meeting.
Not
No, not the next court
Yeah,
meeting,
it will
October
be-
17th.
It's October 17th.
Yeah.
Will be the second reading of this ordinance by the Gilliam County Court. So in filing, let me ask one more question. In filing an appeal for this, can this happen prior to the passing of the second? I mean,
No.
okay.
No, it can't. I mean, the decision is not final, that's what I made that point.
Until that's-
Until it's reduced to writing and it's
Right.
executed by the court, it's not
Okay.
final.
All right.
And I would also point out that the ordinance doesn't go into effect until 90 days has passed. the
Okay.
second reading.
I don't know that that
Right.
prohibits
It
filing.
doesn't,
Right.
that's
Yeah.
a separate
Yeah.
thing,
Mhm.
but that's when the changes would actually be made.
Yeah, I am aware of that.
And that is why there was usually an emergency clause on that,
Right.
because 90-day waiting period.
Okay. Okay, Ms. Postgate, do you have any comments?
No, thank you, Judge, I don't.
Okay. Anything further from you, Ruben?
No, thank you, Judge.
Okay.
Do the order, do we do that at the next meeting?
Could I ask a question?
Yeah.
Why did you not listen to anything we said? Why was this passed? What was your reasoning for passing this and having complete disregard for the adjacent landowners and how this will affect us? And the outcroppings that are historic. I just want to know why.
And, actually, if you, Judge Schaefer, if I may,
Yeah.
just briefly answer that. The job of the planning commission and the court here is somewhat limited in that if ODOT, who's the proponent here, makes establishes that they have the right to use this property in the manner that's allowed under Goal 5, the court does, and the planning commission, they don't necessarily have the option of just saying no. If the bases are met for approval, it's not really just up to the straight discretion of the court.
At what point are the Gilliam County residents protected by the court? I mean, isn't that their job? and the comprehensive plan that fully states that the outcroppings wouldn't be touched.
The outcroppings were addressed in the findings of fact.
Not completely. And then again, it wasn't even addressed that the gap between the receiving of the proposal and the first meeting, and not everybody was even notified. How can we move forward with those discrepancies?
Or seems like.
I believe there was notification that was.
No, I did not receive any notification, Ruben. None whatsoever.
Okay, I'm gonna, yeah, but I don't wanna go any, yeah, I agree that I'm a little concerned. For me personally, the information getting to the landowners.
Had it
or the
not been
the
for
neighboring
me.
landowners,
The notification came from me to those landowners that are closer to that site than myself. Not from the county, not from the planning commission, not from the county court. It came from, I guess, the Board of Anderson.
yeah. You know, I will say that the.
And that's not right.
Yeah, by the time it came to the county court's ability to take a look at this, I know that the landowners were notified and did have that information, because you had been at a couple of the planning commission meetings. There was information that you had brought to the planning commission that they had only a certain window of time to be able to, get this accomplished.
But isn't the planning commission under your rule, I should say?
And to follow due process as far as notification of the landowners. They did, I think, probably got notified of the new house that was gonna go in, but certainly not of this.
Right.
And they were within 1 day of one another.
Yeah, I can't, I don't.
And
I
that
don't
was,
think-
that was questioned
yeah.
in the beginning. That was
Right.
I think one of the bones of contention is that was brought up in the very beginning, is
Mhm.
that the process was a little lacking here
Right,
and has gone ignored.
yeah, I can't answer the fact that the court does not oversee the planning commission. It is, we do appoint the people that are on there, but they have their own, they go through their own process, and it's when they are unable to come to an agreement that this moves to the planning commission, or to the county court, and so we have no recourse over the top of them at all, simply because if it is appealed at the planning commission level, it moves to the county court level. So, what happens prior to it coming to the county court, the court has no information until the time that it does come to us. And what I understood of this was that there was so much information that came to the county, or to the county planning commission at the latter part of that 180-day window, that they didn't feel that they were able to make the.
And whose fault is that? That is theirs for not letting us have enough time.
Mhm.
So the Gilliam County residents, again, get screwed.
Well, I believe this moved to the county court in June?
July.
July.
Yeah.
The planning commission decision was made July 2nd.
Okay.
Yeah.
And so we got it right after that. I guess really what we were looking at is the month of July, the month of August, and here we are, the latter part of September. I'm not really sure, how much more time could have been needed.
Would have been needed January 24th, May 22nd. That's a big window, that's a big gap.
Okay.
And then all of a sudden, they were upset that we didn't get that information to them. Whose fault is that?
I can't pinpoint.
I know,
can't,
I think
yeah.
you explained our position as well as,
Yeah, I don't. I know this is a very controversial thing. I was on the planning commission the first time that this came back in mid-90s, was it, or mid-2000. It was controversial then, and I don't think anybody was more disappointed with the fact that this went from the planning commission to the county court than me. It was that, you know, things couldn't have been mitigated, negotiated to a point that everybody felt comfortable. But,
And given that, I would have opted for, well, you know,
yeah. Okay.
instead of approval, you
Yeah. Do we
Play
have
it safe.
any other comments that may come? Okay. Well, with that being said, we shall pick this up again on October 17th for the second reading. Well, our county court meeting begins at 10 o'clock. We haven't got it scheduled exactly. We
Don't make it at 10 a.m. like the last hearing.
Okay.
Let's have a few minutes to get our meeting moving before we go into a hearing.
Okay. We could, what do you think, Commissioner? 11 o'clock, 1 o'clock for?
Well, I mean, I'm just saying 10 a.m.
Yeah, yeah.
You know, we're doing the flag salute the same time we're opening the hearing.
Okay. All right. We will. We'll extend that to a little bit later in the day.
Yeah.
Okay.
Okay. All right. So with nothing further to add in this hearing, we shall adjourn.